Now, amid the sedition law debate, Centre has filed an affidavit defending the law. The Centre has asked Supreme Court to dismiss all the pleas that are challenging the sedition law. In its affidavit to the Centre, in its affidavit to the Supreme Court, the Centre has said that the three-judge bench led by Chief Justice N.V. Ramana, that the verdict in the Kedarnath Singh versus the state of Bihar upholding the sedition law is binding and does not need reconsideration. Now, it has also said that the bench cannot examine the validity of the law, as a constitutional bench has already done that. They have already examined all the aspects of the sedition law. Now, the special bench will be hearing this matter on Tuesday.
What had happened was the articulated legal position of the central government was awaited by the Supreme Court on this particular matter. That response, by virtue of this affidavit, now has come by, where, like you rightly mentioned, the government of India is telling the Supreme Court that there is no need to refer or to have the earlier 1962 Kedarnath Singh judgment be relooked at by a superior bench composition of the Supreme Court. Now, what is this Kedarnath Singh case? It was a landmark judgment of 1962, by virtue of which the apex court had upheld the constitutional validity of sedition law. However, it attempted to restrict the scope of its misuse. The Supreme Court back then, by virtue of a five-judge bench composition in the Kedarnath Singh case, had laid down certain guidelines which would go on to determine what offences fell within the ambit of sedition or not. The Supreme Court back then had clearly stated that unless accompanied by an incitement or call for violence, criticism of government cannot be labelled as sedition.